So thanks to you all for zooming into this. My name is Rainer Forst. I'm director of the Normative Orders Research Center, and I very warmly welcome you to this Tribunal of Reason that we're having this afternoon to discuss Sofie Møller's new book. It's a great pleasure to be able to do so. Sofie is a postdoc here at Normative Orders. She joined us in 2017, and she did so after receiving her PhD at the European University Institute in Florence, where she wrote a thesis that the book we are discussing grew out of. And her committee members were Paul Geyer, Markus Willaschek, who is also here with us, and Nehal Buttar. Sofie, before going to study at Florence, collected a number of degrees, one in semiotics, and a master's in semiotics from Bologna, a master's in philosophy from Copenhagen. And when in Florence, she began with a law degree, which she received from Hearst. So she's well qualified in many ways to write the book that she did. She received various scholarships and distinctions. Recently, for example, a Humboldt fellowship, which came at the same time as the Normative Orders Fellowship. She could only take one, but it attests to the quality of her work, which is, has been published in various well-used journals and books. She writes on Kant and Kantian themes, and the crowning achievement of her work so far, and there's much more to come, of course, is the book on Kant's Tribunal of Reason, Legal Metaphor and Normativity in the Critique of Pure Reason. At Normative Orders and in many other places, we all search to solve the puzzle of normativity. And I think Sofie's attempt is a great attempt to do so, because in searching for the core of the normative order of reason in Kant, with Kant, she takes the metaphors of the legal realm seriously and interprets these metaphors as actually the path to follow if you want to understand the normativity of reason, and therefore also the normativity of all the norms that reason grounds. So I'm really thrilled that we have this event and turn over to Sofie, who's going to give a short introduction to the main thoughts of her book.
Thank you, Rainer, and thank you all of you for logging into this event. I'm sorry for being late due to these strange internet problems. I think always when you need it the most, these technical things, they seem to let you down. But I'm very happy that you can all join, and I'm very happy that we have this online event, because this means that people can log in from many different places and we don't have to be limited by the geography. I'll very briefly tell you a little bit about the book, and then we'll discuss it more with all the commentators. I thank the commentators for engaging with my work, and I'm looking forward to the discussion. But a little bit about the book before we begin, because it's a book I've been thinking about for a very long time, and it comes out of a sincere wonder about Kant's work, because it's so strange that you have this main work in theoretical philosophy, a work that's supposed to be about knowledge and about cognition and about pure reason. And then in all of the different parts of this work, you find references to courts, to legal arguments, to lawyers, to witnesses. There's even a funny passage talking about a witness who changes his clothes so he looks like somebody else. And there are all these very, very practical examples. And I couldn't figure out, why do we have all of these references to law in a book that's about pure reason? So that's what I set out to understand. And what my aim in the book is to look at all these different metaphors. I call them metaphors in a very broad sense. that we have in the Critique of Pure Reason to understand what it is about law and reason that's so fundamental that a philosopher like Kant keeps putting them together in a book like this. And what I figure out and what I argue in the book is that Kant understands reason as having the same structure as a legal system. But it's very important that this is a legal system in the natural right framework. And it's a natural right framework that we have to understand in a non-voluntaristic way. And that's what I show in the book. And I think part of my argument in the book is that the work of the Critique of Pure Reason is to make cognizers similar to authorized judges within such a system by proving the legitimacy of the laws and the conditions under which valid judgments can be pronounced. And I do this by going through all of these different metaphors, images, analogies that we find in the Critique of Pure Reason. And there really is an astonishing amount of these in the book. In my book, I start out by looking at the very central metaphor that Kant gives us of the Critique of Pure Reason as providing a passage from a pre-critical state of nature, as he calls it, a state of confusion, use of force among philosophers, into what he envisions as a peaceful, lawful condition after the Critique of Pure Reason. That was at least his hope. I don't think we've entered that condition yet, but at least it's not a complete state of nature, I think. I then look at laws as part of this framework. And you might say, well, laws, that's a technical term for Kant. But I think that if we put laws together with all of these different images from the legal sphere, we see that Kant has a normative understanding of laws, and he has a normative understanding of justification, of the use of justification in epistemology that makes sense when we look at laws in this framework. And that's also why I look very much at the quid juris metaphor that introduces both versions of the transcendental deduction, but I think it's also central to how Kant understands the lawfulness of reason, because he wants all cognizers to be able to challenge claims and say, quid juris, with what right are people making these claims? And to do this reading, I go into a very technical discussion of the transcendental deduction. And reread it as understood as part of a judicial authority. I then take a brief detour into practical philosophy because there is also a practical inner tribunal that is important to understanding Kant's understanding of law and reason, and that's the inner tribunal of moral conscience, which is also very important in the Christian images, and it's also, of course, from Roman law. So I think it's important to understand this traditional use of a legal metaphor that Kant incorporates into his philosophy. I also look at the Critique of Pure Reason itself as the tribunal of reason and all the ways in which Kant presents his investigation in the Critique of Pure Reason as a tribunal and as a critical examination, where he really, in the antinomies, he really says that we have witnesses and claims. And he says that the whole point of the Critique of Pure Reason is to enable us to distinguish between what he calls rightful claims and groundless pretensions. That's really the whole point of it. And that is what a judge is supposed to do. Look at the laws and distinguish between the rightful claims and the groundless pretensions. And I then end up with a discussion of systematicity, because I think part of what is so important in Kant's understanding of law is that it provides a system. But it's a very particular system because it's a system that incorporates debate. It's a system that incorporates conflict and has a procedure for resolving conflicts. And I think that's very important in understanding the type of system that Kant envisions for reason. So that's very briefly what I do in the book. Today, we also have a moderator of the discussion, Lara Scalia, who is a postdoc at the University of Warsaw, has kindly offered to moderate the discussion. So I'll give the word to her now, and she will present the first commentator. Thank you very much. I'm looking so much forward to this.
Thank you. And thank you for the opportunity to discuss with you more. Before we start, just a couple of organizational details. Although I know that we are all familiar with this Zoom nominal modality, but just remember to mute your microphone unless you're speaking. And in the first part of our session, we will have an hour and a half research for commentators and for Sophie's reply. And then in the second part of our session, we will have roughly half an hour for an open discussion. And for that, write me in the chat so that I can put you on my list. And I hope not to oversee anybody. Now, the first commentator for today is Professor Markus Willaschek from the Goethe-Universität of Frankfurt and member of the Research Center Normative Orders. You will have approximately 10 minutes for your comment, and then Sophie will have 20 minutes for her reply. Go ahead.
Yes. Thank you, Lara. Thank you, Sophie. Thanks, Rainer. And hello to everyone. It's a great pleasure for me to speak on this occasion. What I'm going to say may in part overlap with Sophie's own brief summary of the book, because I'm also not trying to go into many of the details, but rather give an overview and say why I think it's really an important work. So please excuse if there are some repetitions here. But on the other hand, often it's good to hear things twice. Some people have speculated that Shakespeare must have been a lawyer because of the pervasive use of legal language in his plays. By the same token, one might suspect that Kant too must have been a lawyer because of the legal language and legal metaphors he uses in his work, particularly in the Critique of Pure Reason. While individual metaphors such as that of a tribunal of reason and the juridical character of the transcendental deduction of the categories have been widely noted and discussed in the literature, so far there have not been a sustained interpretation of all juridical metaphors in the first critique and the way they hang together. Sophie Möller's book is the first extended discussion of the Critique of Pure Reason under that perspective. In providing such an approach to Kant's opus magnum, Sophie makes a significant and important contribution to Kant's scholarship. Based on an astounding knowledge of early modern jurisprudence and legal thinking, she is able to interpret Kant's legal metaphors in their historical context. At the same time, based on an impressive acquaintance with Kant's philosophy, she succeeds in throwing light on some of the most important theses and ideas in Kant's first critique by exploring in great detail the meaning of the legal terms and images Kant uses to present them. Let me mention just some of Sophie's impressive achievements in this book. Among other things, she shows that the legislation of reason, Kant talks about, must be understood on the model of a natural law account, something Sophie just mentioned, which allows her to read reason's legislation, I think very importantly, in a non-voluntarist way, as recognizing and approximating pre-existing laws of rationality. Also, she considers the transcendental deduction of the categories and Kant's distinction between quaestio facti and quaestio juris, and argues against Dieter Henrich's influential interpretation that the argument of the transcendental deduction itself is not modeled on the juridical deduction writings of the 18th century. Rather, it is only the aims of the transcendental deduction that are analogous to those of the deduction writings, in that the deduction, Kant's deduction, tries to establish the legitimacy of our use of the categories. According to Sophie's reading, the transcendental deduction as an argument is structured not in analogy to the deduction writings, but in analogy to an act of juridical imputation, which, like the B deduction, proceeds in two steps. First, an imputatio facti, than an imputatio juris. So that explains Henrich's famous observation of the 2 steps of the argument. Next, Sofie addresses the metaphor of the critique as a tribunal, in part by identifying the different roles played in such a tribunal, judge, jury, witnesses, testimony, etc., in the Kantian text, and compares it to the other application, we heard that before, of the tribunal metaphor in Kant's philosophy, namely the case of moral conscience. Moreover, she discusses the authority of reason, which, on her reading, requires the distinction between the phenomenal and the nominal thinker. Authority residing with the latter, but applying to the former. And she emphasizes the political and social implications of reason's authority, something perhaps Susan Schell will later comment on. Finally, Sofie turns to Kant's central criterion of scientificity, namely systematicity. So only if something is a system, it can be part of a science. Comparing the idea of legal systematicity to the other images Kant uses in this context, that of an organism and of a building, he concludes that it is the former, the legal systematicity, that is most fundamental for Kant. Reason's systematicity, she concludes, is the systematicity of the law. Beyond offering detailed and illuminating interpretations of the individual juridical metaphors, her overarching claim thus is that reason itself is structured like a juridical system. Reason's legislation is analogous to political legislation. Systematicity of reason is juridical systematicity. The critique functions as a tribunal, and its aim is to progress from, as we already heard, a philosophical state of nature to a state under the rule of law, and to turn the reader of the critique into a competent judge of philosophical claims. If this is correct, as I think it is, any interpretation of the first critique that does not take into account its legal imagery is seriously flawed. In closing my brief remarks on Sofie's book, I would like to raise a question that she addresses only briefly at the very end of the book, namely why Kant conceives of reason and its critique on the model of a legal system, and why he uses predominantly legal metaphors and not, say, biological or mechanical or political ones. The answer Sofie there considers and rejects is that Kant adheres to a rationalist conception of the law, and the law itself is a manifestation of reason. Sofie rightly rejects this explanation, since it would make her own approach viciously circular. Reason is modeled on the law because the law is modeled on reason, right? That wouldn't be very helpful. But if that explanation must be rejected, what then does explain why Kant uses the law as his model of reason? Of course, I cannot try to offer such an explanation in the few remaining minutes of my comment, but I would like, at least very briefly, to sketch a hypothesis. It consists of 2 points. The first point is developed extensively in Sofie's own book, namely that the critique of pure reason, at least on one important level, is a treatise in epistemic normativity. It aims at distinguishing between responsible and irresponsible, legitimate and illegitimate judgments and knowledge claims in mathematics, science, and metaphysics. Moreover, it explores the justification of legitimate judgments in these areas and explains why and how the illegitimate ones lack justification. Kant was perhaps the first philosopher to fully comprehend that epistemology is a normative discipline, that knowledge, science, and reason are part of a specifically epistemic normative order. Now, the second step of my hypothesis about Kant's use of legal metaphors is that the law is our paradigm of a normative order. That is so because the law, particularly Roman law and the German law influenced by it, is the most extensively codified normative order we have. By contrast, ethics, science, religion, etc. are normative orders too, but many of their norms are not explicitly codified, so that it is not easy to see how they are structured and what their norms are. If you want to know the legal system of a country like Germany, by contrast, all you have to do is to look at the law books, such as the Bürgerliches Gesetzbuch, Strafgesetzbuch, and so on. And I think that the situation is only superficially different for countries with common law systems, such as England and the US. Moreover, there is a highly sophisticated theoretical apparatus called jurisprudence and legal theory that allows us to analyze and discuss legal systems. Now, if we take these 2 points together, I think we have a plausible explanation for why Kant makes the law his model of reason. Why reason, including practices such as inference, argumentation, and science, is a normative order, the law is our paradigm of a normative order, and legal language is the most explicit and sophisticated vocabulary we have to discuss normative questions. So this, I here come to an end, and let me say in closing that I had been acquainted with the idea that legal metaphors are important for understanding the critique of pure reason, actually since I was a student, through the work of Friedrich Kaulbach, whom Sofie also cites as a source of inspiration. Now, I must admit that for a long time, until quite recently, I did not take this idea very seriously, partly because I thought that these are only metaphors, and what counts are Kant's arguments, right? Now, in showing how pervasive these metaphors are and how they structure Kant's accounts of reason as a whole, Sofie's book has convinced me that one cannot fully understand the critique of pure reason without paying close attention to its legal language and imagery. Thank you.
Thank you, Marcus. I'm very happy to have converted you to the non-rhetorical reading, because I didn't mention this in the beginning. But something I have, an objection I've encountered a lot in during this project has been, these are rhetorical devices. This is a way of making the reader understand something. It's simply Kant was teaching natural law theory 4 times a week while he was writing this book. It was at the top of his head. It was easy for him to use this to make all this easier to digest for a reader. It was a framework that the reader would know. And I agree, of course, that's part of the reason. Of course, Kant would like to be understood by his readers. Of course, he would use a well-known example to explain his understanding of reason. But what I try to show in my book is that there is a deeper reason why this was such a good example. It's just as Marcus says, it's because it's a paradigm of a normative order, we might say, also being here in the normative orders building. But it's a very special type of normative order, and what I think is so interesting about the way Kant transforms a lot of the vocabulary, the imagery from natural right theory, is that he transforms it to include critique. He transforms this into an understanding and shows that also in the law we have tools for resolving conflicts. We have tools for having procedures for what to do when there is conflict. And I think that is also part of why these metaphors work so well for his understanding of reason, is that it is an understanding of a normative order that has a procedure for engaging with conflict and including these different points of view within itself. And I think that's part of what is so important about the law as a paradigm for reason. Another objection that you might make to my work is that German law hadn't been codified when Kant wrote the first critique. It came just after. So you might say, well, he didn't live in a system with a codified law, and there were many examples of judges interpreting the law at the time very, very freely because they wanted to use their reason rather than the letter of the law. But of course, he had other examples of codified law. You mentioned also Roman law as a very good example of that, and the whole natural law tradition as an endeavor to make positive legislation match principles of justice and under a rational account of the law. So that's, I think that whole tradition is very, very important. And I think that is why it's so important to see reason as matching law, not just as a mere rhetorical device, but exactly because they share these very, very deep structural similarities and similarities in purpose. Thank you for this comment.
Thank you, Markus and Sophie. I am very honored to introduce our next commentator, Professor Susan Schell, who is Professor and Chair at the Department of Political Science at Boston College. Welcome in Frankfurt.
Thank you. Well, it's a great, I wish I could be there. I'm sure I'd be getting better food, and it's an honor and pleasure to be able to contribute to the launching of Sophie Müller's superb new book. The outstanding virtues of her book are, as I see it, at least threefold. I'll mention three. Firstly, I think it's an exemplary model of contextualism in the best sense, in which contemporary practices are brought to bear, not in an effort to historically condition or otherwise limit the reach of Kant's argument, but to clarify its meaning and enrich our understanding of that argument. Second, her book not only provides the most thorough analysis to date of the various legal and juridical metaphors that populate the first critique, it also offers the most convincing response I know to what Møller neatly calls the Herdarian Dilemma, or to put it otherwise, the problematic source of reason's authority to serve as judge in its own case. As such, it takes on the crucial but often neglected task of seeking out the justificatory ground and aim of a critique of pure reason as such. And third, finally, it sheds new light on, I think, the unity of reason as Kant saw matters, and with it the peculiar interdependence of theory and practice. Drawing on Kant's own insistence on the indispensability of symbols in the expression of crucial philosophic concepts, she presents the image of the tribunal as master metaphor for the activity of reason in its various critical roles, from accuser to defendant, from witness, from opposing claimants to final judge and arbiter. Now, Kant, as she shows, Kant's use of legal metaphors tends to cluster around two distinct sites: the crucial A and B deductions and the doctrine of elements, and the famous presentation in the doctrine of method of the resolution of pure reason's dialectic as the exit from a state of nature into a legal condition. We'll leave the details of Müller's fascinating reconstruction of the transcendental deduction to others. Professor Willaschek has already commented very, very illuminatingly on that. I will only note that it is here that her sophisticated contextualism especially shines. First, by drawing on the multiple historical meanings of both deduction in a legal sense and the related distinction between the question of fact or deed and the question of right or law. And second, by suggesting the distinction between natural and positive law, as conventionally understood in Kant's time, as a template for understanding the normative character of Kant's transcendental epistemology, which names not so much to describe judgments under reading as correct them in light of a higher set of critical norms. And Müller's treatment of the tribunal metaphor in section 2 of the Doctrine of Method is equally original and far-reaching. Here too, the tribunal in question is presented not as an ordinary judicial court whose scope and limits are set by positive law, but as a higher court of review before which opposing legal claims, fueled by the competing interests of reason, find peaceful reconciliation through a resolution through a decision drawn, as Kant states, from the principles, quote, of the fundamental principles of reason's original institution, unquote. Now that reason's critical tribunal both establishes reason's lawful condition and is at the same time authorized by general laws of reason's original institution, raises a difficulty, I think, that I would like to spend the final moments of my remarks exploring. This difficulty to extend the metaphor is political, albeit in a more complicated, richer sense than that which Dr. Møller quite properly, in my view, subordinates here and throughout her study to the legal. But the issue, I think, is precisely how the legal condition, which is as such merely an idea, is to be made actual, or to put matters otherwise, how reasons itself originally or again to be instituted. Both the establishment of such a condition and the institution it requires is, I would suggest, less like the action of a judge, finally, than of a head of state or founder who executes, as it were, the law of nature, and thereby not only enforces the decisions of the court, as with actual executives, but makes courts as such materially possible. For example, by setting up the appropriate institutions, to cite Kant's Metaphysics of Morals. And it's here that I at least found Møller's arguments especially searching and helpful. For as she shows, the establishment of a lawful condition is not a fait accompli, but a process that must be reenacted again and again in the mind and heart of each who would claim a share in universal reason. And yet the accompanying transformation in each person's way of thinking is not automatic, but requires, I think as Kant puts it at this stage of his philosophic career, an individual act of courage, as he puts it both in the first critique and the contemporaneous What is Enlightenment. And that courage presupposes in turn a certain material political framework. In this case, the bulwark of tolerance under Frederick the Great that would soon disappear. Now, Kant defines, now I don't mean to say that to reduce all of this to the material political conditions, but simply to say that the metaphor is, I think, can be enriched beyond the merely legal if one thinks through what the equivalent to a head of state, the kind called for to really establish a juridical condition on the practical side might mean on the theoretical side. Kant defines politics, which he finally gets around to defining it, only in perpetual peace, as both applied right and as the art of using nature to govern human beings. And it is probably not an accident that he defines and treats politics thematically only after the death of Frederick, whose enlightened politics could no longer be taken for granted. If one can apply those definitions backward to Kant's earlier juridical metaphor, the transformation in a person's way of thinking necessary for establishing a lawful condition among lawfully united reasoners is akin to that transformation in a people's way of thinking that is necessary to establishing a true republic, itself an ideal that no actual people can ever realize perfectly or without the intervention of some external force. And I was indeed struck in rereading the methodology of the first critique in light of Møller's astute observations. How much playing to the political rafters goes on? How much reassurance is provided not only to the student nervous that the critique will threaten his or her own cherished moral beliefs, but also to the religious and other powers that be who might well question the wisdom of allowing a critique of reason to go forward publicly. I would therefore offer a slight and very friendly and verbal amendment to Dr. Møller's statement that, quote, the legal structures of reason are the condition of the possibility of its political nature, unquote. Namely, that something further is required if those structures are not to remain wholly latent. That is, if reason is to be instituted effectively. That something spans the gap between possibility and actuality, between the ideal and the real, that is implied by, I think, the very concept of normativity. And it is comparable, if not isomorphic, with what Kant elsewhere calls the task or problem of politics. Now, one of the other results of her study, although not one emphasized in what is already a very rich book, is the ways in which it illuminates another central metaphor, namely critical as in crisis, as in the moment in one's youth at which one's reason either takes charge, takes the reins, or one remains, in Kant's terms, permanently immature, that is to say, unmündig or without a voice in universal human reason. You could say that critical transformation, like the transformation of a people into a commonwealth, is a kind of rebirth into a state of autonomous agency. But if this is so, the organic and legal metaphors may be more closely linked than first appears. But let me end here with a final word of praise, along with a really highest praise, along with a political question for further conversation. Like many of the finest studies of Kant's thought, Møller brings to light a long-neglected layer of argument that subsequently, after she's brought it out, seems obvious, and that serious scholars will henceforth need to address. In short, her book is, in my opinion, among the few that constitute a must-read for any serious member of the discipline. As to that final political question, in quotations, how, in borrowing metaphorically from the legal conventions of his day, in ways that Møller so ably shows, might he also aim to transform them? And what I have in mind, and it's the way I'm sort of drawing on Marcus Willaschek's very helpful comments, is the way that Kant, well, he's not a voluntarist and he's a rationalist of a sort, he is perhaps not a conventional rationalist either, for whom, as I understand the rationalist tradition, that the ultimate standard is cognitive. That law isn't the primary thing, that it's knowledge of justice or the common good or some independent standard which is cognitively accessible to us. And that reason, therefore, is primarily a cognitive or not a law-giving faculty. And in transforming that understanding of reason, it seems to me that Kant does something very radical, not only philosophically, but also politically. So I just leave that, as a possibility for further exploration.
Thank you very much. This was a wonderful comment, and there are so many things I could comment on it. To the comment, I was very happy that you caught on to the idea of the indispensability of symbols. I like that very much, because there is this idea in Kant that the symbol provides us with something like a tangibility of something that we cannot have any kind of experience of. And of course, reason is absolutely an example of that. It's something that we cannot know empirically. So having an empirical example of what it might look like can really help us have something like a better understanding of reason. And I think that that's very much a guiding thought in my book, is that having this example gives us an understanding of reason that we wouldn't have if it were just an abstract account of reason. And I think that that's very important. Also about the arguments and their meaning, I think a lot of the literature, in my view, has gone astray in looking at Kant's legal metaphors, because it's always been about argument structure. It's always been about what do these metaphors tell us about the argument structure. And what I try to show in looking at the systematicity and the idea of a system and the purpose of reason and the purpose of these structures, etc., is exactly to show that there is a larger meaning that they point towards, that's not just about the minute structure of arguments, but it's about how all of these arguments hang together and what they show together. And I very much appreciate that you mentioned this again. And I know about the politics and law that I have towards the end of the book, and that was why I very much wanted to discuss this with you, because this is a little bit, but I think it's just a question of, we both agree that we need both of them, right? And we both agree that they are necessary and sufficient together. And I put a little bit more of an emphasis on the law, because I have this understanding of, well, the community only becomes a peaceful community. It only becomes a community where we can argue rationally with one another once we have some rules for the intervention and some rules for how we deal with conflict. For conflict not to be resolved through force, we need law. So that's why I put a bit of an emphasis on the law rather than the political. So that's why I say that the lawful interaction and the laws of reason are what allows us. So the fact that we share the same understanding, if we, read the Critique of Pure Reason and we think about it, etc., we will come to the same understanding of the laws of reason, or we will at least be able to discuss them rationally. That's why we can have this civilized community of thinkers that will then allow us to have this moment in which every reason is something in which everyone has a voice. Well, that's because reason is lawful, and that's why we can respect each other's views in this way. And I absolutely agree, it's not sufficient on its own. We also need the political instantiation. We also need the community of thinkers. We absolutely still need the debate. And it also, I really like what Kant says about the power of judgment in the tribunal metaphor. And as he says, it's something that's ripened over time. It's something that people have ripened in discussion. So I think I absolutely agree that we need both. My emphasis is a little bit more on the law because I think that that puts the structures, but I of course think that there is the risk if you take the law metaphors too far and you just run with the law metaphors, is you have somebody who sits and judges by the tribunal of reason and then tells everybody else that they're wrong and shuts down any kind of debate, because if you think of the judge as somebody who has the last word, well, then you've absolutely misunderstood the purpose of the legal metaphors, because then you would have a dictatorial use of reason, you would have a dogmatic use of reason, which does not allow critique and debate and all of these other very, very important things that we also find in Kant's more political metaphors. But I still think it's important to make a little bit of a distinction, because we have the space for politics, I think, is made up of the legal structures. But what's interesting is, of course, that the debate, the community, etc., can then discuss these structures and can then say, well, maybe we got something wrong here. Maybe there was something we misunderstood. Maybe we misunderstood these a priori principles or whatever. So I think that's also important to say. The law sets the limits, but then the politics in the practical political sense, but also in the use of reason, can then modify our understanding of these limits. So I think it's absolutely a back and forth. I put a little bit more emphasis on the law also because that's, of course, what the book is about. But I agree that they are both together necessary and sufficient as well for each other. Thank you very much for this.
Thank you. And now the next commentator is Dr. Jakob, who is postdoc at the Research Center Normative Orders in Frankfurt.
Well, thank you for having me, for inviting me to discuss this terrific book. I think my comments follow on nicely from Professor Schell's comments, in a sense that I also want to look at Sophie's project from the perspective of Kant's philosophy of law or right. But I want to ask, what happens when we project some of the juridical notions that Sophie uses to illuminate the first critique back onto the original context? Because after all, a metaphor is often a kind of two-way street, so we are likely to come away not only with a different understanding of that which is supposed to be illuminated, but also of that which serves as a metaphor. So what I want to ask is how Sophie's framework of legal metaphors changes or impacts the way we understand these legal terms themselves, and I think probably ultimately Kant's philosophy of right as a whole. And I want to approach this question from a particular perspective, namely a Hobbesian reading of Kant's political philosophy. And I do so because I think this reading is particularly well suited to highlight the crucial respect in which the domain of right differs from the other domains of rational activity. So both in Kant's theoretical philosophy and in his ethics, and I think Sophie describes this very clearly, the discipline of reason can be understood as a form of self-discipline. It's concerned with the way in which an individual thinker or agent can evaluate their own thinking or willing, respectively, objectively evaluated. Now, the domain of right, I think, is fundamentally different in this respect because it's concerned with the problem how a plurality of agents can coordinate their interactions. Hence, the idea of a split of the self, as Sofie calls it at one point, into law-giving reason and law-following phenomenal self is translated or transformed into a split between law-giving sovereign and law-following subject. And that means that in the domain of right, we're dealing not only with a priori laws that spell out the very idea of a freedom-based public order, but always also with positive coercive laws that give material reality to this idea. What I want to explore in my brief remarks is to what extent the way in which Sofie employs the legal metaphor leaves space for this Hobbesian dimension in Kant's political philosophy. And I want to do so in relation to two specific contexts in the book, namely, first, the contrast between the state of nature and lawful condition in epistemology and politics respectively, which Sofie addresses in chapter 2 of the book. And second, Sofie's discussion of Honora O'Neill and the relation between legal and political concepts in chapter 8 of the book. So at the heart of chapter 2 is an analogy between the move from a state of nature into a lawful condition in the domain of right on the one hand, and an equivalent move from an epistemological state of nature to a corresponding lawful condition where reason has gone through the process of critique on the other hand. And the thought is that in the epistemological state of nature, there are laws, but these are not generally recognized. So laws need to be made effective through a critique of reason. This, Sofie argues, is also how we should think of Kant's political philosophy, where, quote, the will of the legislator determines what is laid down as right, and if these laws correspond to natural right, they are valid. Now, I don't think that this is in fact how Kant thinks of transition from the juridical state of nature to the civil condition, at least on the Hobbesian reading that I have proposed. Plausibly, the very idea of right imposes certain formal constraints on public lawmaking, but positive law does not simply give material effect to a priori law. Kant repeatedly says, and I think these are some of his most Hobbesian moments, that positive law gets its validity from its source rather than its content. So while in the speculative context, the transition from state of nature to a lawful condition may very well be described as a process where laws are discovered, when we project this back onto the juridical domain, I think it sounds a bit too Lockean for me. Political authority does more than simply implement pre-political laws of nature. I'm now moving on to the second aspect and Sofie's discussion of Honora O'Neill, in respect to which I have a somewhat similar concern. So according to O'Neill's well-known political reading of the first critique, the discipline of reason can be likened to an open public debate among fellow citizens and hence be described as a distinctly collective endeavor. Sofie, I think, plausibly criticizes O'Neill for not acknowledging that the very possibility of agreement in debate presupposes that we each discipline our own reasoning. In other words, that the lawful structure of reason's authority, as she calls it, is a normative presupposition for rational debate and community. Notice that Sofie here uses the term lawful structure, not literally as referring to an actual civil condition, but in a metaphorical sense of a condition where shared rational structures are in place. That means that while Møller and O'Neill disagree on the way in which the authority of reason is individual or collective, the idea and significance of public authority is actually absent from either account. At one point of her discussion, Sofie argues, for instance, that, quote, the authority of reason doesn't depend on the authority of a person or an institution. Now, while it's hard to deny that this is a plausible characterization of Kant's theoretical philosophy and maybe even of his philosophical project as a whole, I think there is a distinct sense in which the domain of right or politics constitute an exception in this regard. Political authority cannot be reduced to the authority of the better argument, but is at least ultimately the authority of the law-giving sovereign and hence of an artificial person. And for me, that raises the question, what even defines something like a political reading of the first critique if political institutions and coercive law, which are so constitutive of the juridical domain for Kant, make no appearance at all? Now, what's the upshot of all this? Well, I think first there's a possibly trivial insight that any attempt to point out similarities across different domains of rationality is bound to at least sometimes downplay the extent of the distinctness or specificity of these respective domains. So I think Sofie actually addresses and shows awareness of this problem in the book's fascinating remarks on method. But I think one more interesting question one could ask is what the contrast I've pointed to tells us about the development of Kant's own political thought. So Sofie points out that while writing both editions of the First Critique, Kant gave lectures on natural right that closely followed thinkers such as Achenball and Baumgarten. My Hobbesian reading, by contrast, takes its cue from Kant's late Doctrine of Right. In between, Kant's thinking seems to have moved away from these traditional natural law frameworks into a more Hobbesian version of right as a distinct domain of normativity that also is more clearly delineated from ethics. So I think one interesting question that we could ask against this background is, what if Kant had written the Critique of Pure Reason alongside the Doctrine of Right rather than his natural law lectures? Would he possibly have used juridical metaphors differently or more sparsely at least? That's of course a more speculative question. I think one that just shows how many fascinating avenues for further investigation Sofie's book opens up. Thank you.
Thank you very much, Jakob. These are wonderful comments. I think I'll start with the last question because I thought it was a funny question to ask. And I have to admit, I've been thinking about this. What if Kant had written at a time when he had already developed a critical legal philosophy? Would it have been different? And I think we see this in the fact that no other work has this many legal metaphors. Right, it's very typical for this period in Kant's thought, and to an extent also to the pre-critical works. He also has a lot of tribunals, but as he starts thinking more about literally about law and legal philosophy, law as a paradigm of reason disappears. And I can also, so it's clear that something changes. And I think you're right in pointing out that his understanding of right and law moves away from this natural right framework that fitted so well with the First Critique. But if you move away from this very, very specific framework, then I don't think it fits as well with his understanding of reason. And that's why I always say that I think that reason functions like a legal system in this very, very particular understanding, which is not Kant's own. And I absolutely agree that if we were to understand the type of law and legal system that we encounter in the First Critique as Kant's own, I think we would be making a mistake. And part of what I say about methodology is exactly, well, he was writing in a tradition that his readers would have known, that we as modern readers are not as familiar with. And all of these references, they're very scarce, they're not very explicit, and I've had to reconstruct a lot of things. And of course, my very first instinct was to say, well, let's look at the doctrine of right. This must be where we find Kant's understanding of all of these things. And then I realized there are too many changes in between, and it's very, very clear that he's referring to a completely different understanding of the law. Can we then say that this was his own? I don't think so. I think some of the notes and the lectures indicate that he was already moving away from this tradition, but that this is the tradition that serves as a parallel for the Critique of Pure Reason. Absolutely, like you also said, well, what we have in the Critique of Pure Reason is an attempt of saying there are these a priori principles of reason. They are already in the world, possibly because we as cognizers are already using them. So what we give as legislators of reason, as he calls the philosophers in the Architectonic, is we attempt to provide a legislation, but this legislation is only valid if it matches up with the principles already in experience. And that's not something that we find in his own philosophy of right. We don't know whether he thought this at the time of the First Critique. That would be an interesting project to figure that out. But it's very clear that he uses other authors, other thoughts, and things that he had not himself worked through completely yet. And I think it's absolutely clear that it's a very different understanding of law that emerges. Yes, and I think also, well, we already talked a little bit with Susan about the idea of the collective endeavor, the understanding of having in the discipline of reason that we need to have this community there that O'Neill has already focused so much on, and it's exactly my point. In addition to O'Neill's understanding is that we need these structures already there in the presuppositions already present in the cognizers, in the thinkers need to be already present for us to be able to have this type of community and this type of debate. I know that there are passages in the discipline where it sounds a lot like, well, anything we agree on, that will just be the laws of reason, that will be what we can use. But I think that if we look at the legal metaphors, and if we distance the understanding of the tribunal of reason from the political metaphors of debate, the community, then we see that there are some rigid limits to what we can agree on in Kant's own thought. Of course, a Kantian thinking can then move further away from this and move in a more constructivist understanding. But I think, or in Kant's thought, the legal metaphors show that there are some rules of the game that are already given apart from the debate that we can have. Yes, thank you very much for this comment. This was wonderful.
Now, I leave the floor to the last commentator, who is Dr. Martin Sticker, lecturer at the University of Bristol. Martin, you're in.
Hey, can you hear me? Excellent. Okay. Well, first, thank you so much, Sophie, or whoever invited me for inviting me. And then I should say that my comment will be a bit different in the sense that it will be narrowly focused on one specific aspect, namely conscience. I should say that I'm more of a practical philosophy type person. So I'll focus on this one chapter where Sophie makes some very interesting claims about conscience, and I think actually develops a very interesting new reading that I haven't. The main point of which what I call non-cognitivism about conscience is not something that I'm familiar with from the literature. So it's very nice that she doesn't just trace the legal metaphors, but also gives us a really new way of thinking about certain subject matters. Okay, so as we know, Kant describes conscience as an inner court, and hence it is an obvious venue to discuss legal metaphors in Kant, right? Let me first briefly say in what significant way Sophie and I agree and where I think she gets it right. Obviously, we both might get it wrong. And then I'll focus on three critical remarks. So first, according to Sophie, conscience in Kant is a higher order faculty. And that's something that quite a lot of other people have also advocated, even though some people disagree with that. So conscience for Kant is not supposed to deliver first order moral insights. It is not identical to the fact of reason, and it is not identical to respect for the moral law, even though I will later in my third point press Sophie on that claim. But it seems that conscience is doing something other than these things that I mentioned: moral cognition, fact of reason, moral motivation. And I think she's right about that. Then I think it's important that she stresses that the breakdown between the roles in the internal court, the judge, the prosecutor, and so on, that these are, that we should understand them in a deflationary way. Kant, even though it sometimes sounds a bit like it, he doesn't intend to make claims about little creatures living in the big creature and fighting with each other, but rather this is a analytic distinction or maybe a transcendental investigation in how it is possible that phenomenon such as conscience. And then the most interesting aspect of Sophie's take is that she's skeptical, I take it, concerning the idea that conscience is infallible. She doesn't deny that, but she's skeptical concerning basically the standard readings of that, basically readings to try to construct a way how we can understand conscience such that what conscience says, the verdicts of conscience are always true. Sophie would deny that, and I think she's right about that. And I agree with her, even though my own take on that would be different. But today is about Sophie's take, not my take. Okay, so let me make 3 critical points to press Sophie. The first is concerns the internal advocate. The second is her take on self-deception, and the third, the fallibility or infallibility of conscience. So Sophie gives us a really neat story about basically what happens in the internal tribunal. According to her, the judge is, so she says reason, but I take it that's pure practical reason. The accuser is the power of judgment, and the accused is the agent. And then we also have a defense attorney. And that's, and Sophie here, following Kerlach or Collins, claims that's self-love. My first critical take, and I think that's something that Sophie could concede, although maybe she doesn't want to, and then we can argue about that. I actually think it can't be self-love, the internal defense lawyer, because self-love seems to me it's normatively inert. It can't really advance spurious justifications because we would basically rationality is needed for that. So I think it makes more sense to think of the internal advocate as empirical practical reason. Moreover, I don't actually see why self-love should be part of this internal court because it's not a rational process, self-love, right? And it seems that what happens on the internal court is basically an intra-rational quibbling or conflict within rationality between different aspects of our rationality. So I think it would make more sense for it to be empirical practical reason. Now, I think that's not a big problem, even if Sophie conceded this or if she didn't. I think what's more of a problem, I feel like the legal analogy breaks down here a bit. After all, in an actual court, the defense attorney, judgment in Sophie's construction, the defense attorney, self-love or empirical practical reason can be right? And the prosecutor can be wrong or overshoot. And I don't see how that would happen in the internal tribunal, because in the internal tribunal, that role is played by the power of judgment, the accuser, and the judge reason, it seems, always gets it right. So I don't actually see why we would need other faculties specifically, why there would be a role for self-love or for empirical practical reason in this tribunal. I think legal tribunals work because we have two biased parties, right? We have the accuser who wants to go for the maximum punishment, and we have the lawyer who wants to go for the minimum punishment or for a non-guilty verdict. But the weird thing is on this internal conscience conception, we have basically one biased faculty, namely self-love or empirical practical reason. And it would be better if we just cut this out, right? At least I don't see why we can't just have reason and judgment deciding matters on their own. If Sophie really wants to make this metaphor work, then I think she would have to tell a story about how either pure practical reason or judgment can go wrong, so that we need an advocate, defense attorney to speak up for us as the agent in order to correct mistakes by judgment or pure practical reason. Okay. Second point, self-deception and rationalizing. And I really like a lot of things Sophie says about self-deception in Kant. For instance, when she says that cases of moral self-deception are instances in which the process of moral conscience remains incomplete. Self-deception may be able to hinder conscience from reaching a judgment, but it cannot influence the final outcome. I really like that because I think it's a big problem for Kant. Then on the one hand, he stresses we have this infallible faculty of conscience that always speaks up when we do something wrong. And on the other hand, Kant maintains that there's always the danger of self-deception. He constantly gives examples of rationalizing self-deception. He thinks it's a constant danger for us. But that seems weird if we only have to, basically, if conscience applies to all morally relevant cases or easily could apply to all of these cases and would immediately inform us if we do something wrong. So I think there's a genuine puzzle here. And Sophie has a really nice solution for the puzzle, namely the idea is conscience can't be deceived in the sense that its verdicts would be wrong, but we can postpone the verdicts, at least temporarily, as an agent, right? So if we self-deceive, we don't actually get conscience to judge wrongly, but we basically make it such that we basically, like some lawyers, we have a delay tactic, right? We basically claim, we basically say to the judge, we need a few more months because we just have new evidence coming in. So can we delay these proceedings? So this is really nice and plausible. I think one question this raises is there a phenomenological difference for the agent between delaying the verdict of conscience and getting a non-guilty verdict? Because I think on her reading, we definitely know when we get a guilty verdict from conscience. But if we get a non-guilty verdict, it's not the case that conscience congratulates us and tells us we have done something positively good, but rather we're basically not being found guilty by conscience. That's basically what we get for a non-guilty verdict. But that looks a lot like no judgment, right? Basically, no judgment means we're not being found guilty. And also, if we're not being found guilty, then again, all we have is, lack of a guilty verdict. So I wonder, and that's not a criticism, but I wonder if there's a phenomenological difference or any way for agents to tell whether they've been found guilty or not. And then finally, I think to some extent, maybe Sophie might be still underestimating self-deception in Kant. For instance, when she says that in the case of a morally bad action, the defense advocate might interpret the incentive as mere negligence rather than intentional wrongdoing. What I like about this is that she doesn't think self-deception is just about our motives and whether we acted for the right motives, which sometimes people think. Rather, she thinks that questions of motivation or incentive can impact questions of responsibility, right? And of whether we are actually guilty of something, not just whether it was morally worthy what we did or in conformity with duty, but not from duty. However, I wonder if the analogy here breaks down once again. After all, I take it that in a court, at least in a criminal court, we don't primarily care about incentive. We primarily care about whether an action externally violated the law. Matters of incentives are relevant insofar as that some actions can only be fully specified if we know about the accused motives or beliefs. I think it's called mens rea in juridical terminology. So clearly sometimes intentions matter, but mainly we look at whether someone externally violated the moral law. I take it that, and that's maybe not so much a criticism, but something that I would invite Sophie to think about, whether on her account, or her account gives us reasons to think that actually conscience isn't primarily concerned with motivation, but with external violation of duty. And I think there's a recent paper by Jens Timmermann where he argued that what conscience does is actually look at external violations, and it informs us about external violations, not about matters of motivation. And if that were the case, I think that would also make sense of Kant's claim that we can never really know our motivation, right? Because if conscience would condemn us every time we acted for the wrong motives, then it seems as if we could actually obtain reliable information about our motives by listening to the voice of our conscience. So I think this point is not a criticism, but maybe just to urge Sophie to maybe think about whether you can get even more out of her interpretation here, namely you can make a case for what conscience is primarily concerned with, namely external violations rather than questions of motivation. Final point, infallibility. Kant famously claims that an erring conscience is an absurdity and unthinkable. And there's a lot of literature, people trying to, sometimes basically read Kant's entire ethics such that this claim comes out true. And I think that they often come up with implausible views of a number of areas in Kant's ethics. So I think what would be better is to show that either, or that we basically can give this a deflationary reading where maybe Kant does make a plainly wrong statement here, but also a reading that doesn't require that we reinterpret important aspects of Kant's ethics to basically save 2 or 3 passages where Kant makes these claims. And Sophie's idea is really nice, and it's what I call a non-cognitivism about the verdicts of conscience. According to Sophie, verdicts of conscience are objectively valid, and they can't be wrong, but they also can't be right because they are not really considered, or they're not really intended to express a truth-apt judgment. Here's a lengthy quote where she makes that clear. Conscience is an unavoidable fact, which would be incompatible with the possibility of error. Judgments can be wrong, but facts cannot. As a fact, moral conscience is a moral feeling related to a subject. This moral feeling is the result of the act of practical reason. Kant's claim that an erring conscience is an absurdity means that conscience does not produce judgments which can be right or wrong. Instead, the outcome of conscience is a moral feeling, which the subject can heed or ignore. This account presents moral conscience as a second-order result of a moral judgment rather than a first-order review of an action. So this is really nice. Two problems, though. First, it seems that Kant is borderline deceiving readers when he says that conscience can't be false, because it also, you should have said it can't be false, but it also can't be true or correct. I think that would be nicer. So Kant isn't lying here, but it's a bit, he's not telling us something that seems rather important. I think more interesting, the second and last problem with which I finish, I wonder how non-veridical judgments can be objective. Presumably, the story is something like the feeling that conscience produces is not a pathological feeling, but one from pure rational activity. If that's true, then here's maybe a dilemma. Either this feeling is identical to respect for the moral law, the one feeling from pure practical reason that we know. But then conscience seems redundant, right? It just duplicates respect. It's basically another way of how respect can influence agents. But then you might wonder, if respect wasn't sufficient to move agents in the first place to act, why would it be more effective now if conscience, in retrospect, basically, again, hits you with respect and in order to show you that you did something wrong? Secondly, if you think it's not respect that conscience doesn't articulate respect for the moral law, but another sui generis rational feeling, then what is this feeling? And how does, the existence of this feeling, rational feeling, sit with Kant's claim that there's only one rational incentive, namely respect for the moral law? Okay, great. That's it. Again, thanks for giving me a chance to engage with Sofie's super interesting chapter and book. Thanks.
Thank you, Martin, for this wonderful comment, and thank you for discussing this practical part of the work, because when I was thinking about this, I was always fascinated by moral conscience, because that's where Kant picks up on the idea of the inner tribunal and goes back to the Bible verse. And I always thought it was very interesting that he has the same Bible verse for moral conscience of the inner tribunal as what he has for the idea that of moral autonomy, the idea that we are a law unto ourselves. It must really have been a favorite Bible verse of Kant's. And in the book, I engage a lot with this understanding, because there are so many puzzles about Kant's understanding of conscience, and especially the part about the infallibility is really, really difficult. But I'll leave that to the end of my responses. The first question about self-love, is it really important that it's self-love? Can't we say, well, it's from the student notes, from the pre-critical years, we don't need to consider that. He could have changed his mind about this. It doesn't pop up anywhere else. Might it just be empirical, practical reason that we would have a completely rational process? I think I can grant that. At least, but I think it's important that there are two perspectives involved, and that there is a chance. So you said, well, it doesn't really make sense to have the power of judgment being the opposite, because the power of judgment can't be wrong. But I think it can. I think sort of, the critique of pure reason shows us all the time about mistakes and illusions and things we just haven't thought through properly. So I think the whole image of conscience is also about scrutiny. It's about looking at something a little bit more closely and saying, well, maybe on first sight we were distracted by, well, either self-love or empirical practical reason. We can also just call it self-deception and not really decide which faculty does it. But saying that there was something that distracted us in our moral judgment and we need to scrutinize it, we need to look at it better. And there we can say, well, on our first attempt, we didn't or we might say we didn't use the power of judgment properly, we didn't think things through. There we can say, okay, well, then the power of judgment could be wrong, not wrong when we use it within the inner tribunal that is moral conscience. But in our first attempt, just like Kant always says, well, we never or can never be completely sure about our moral judgments. We might get things wrong. So I don't think that it's that big of a problem that the prosecutor is a rational faculty and we thereby have some kind of fake conflict. I think it makes sense to say that there is an actual conflict because we might have made too quick a judgment in the first instance. So I think that makes sense. Is there a difference between being acquitted by the inner tribunal of moral conscience and the process just dragging on for years and years? I think there is. It's a little bit of a problem when thinking about Kant's account of moral conscience is that he mainly talks about guilty conscience. So we mainly hear about, you know, pangs of conscience, people feeling bad about things. He also has, I think it's a very touching example of somebody who consults their conscience about whether an April Fool's joke was immorally bad, because of course you're lying in the April Fool's joke, which is horrible for a Kantian, of course. But that's just a case where we just shouldn't consult moral conscience on this case, so it doesn't fall under its jurisdiction. But I think there must be a difference between being acquitted, because he does talk about relief. So you don't get some kind of congratulations for being a good moral agent. What you get is just relief of saying, oh, I wasn't a bad person in that instant. That wasn't a bad thing to do. So you get a bit of relief and you get a little bit of a feeling there, at least in some of the accounts. So I think that should make sense. And the dragging on, I think, you do need the self-deception on whether you arrived at a result or not in order to distinguish between the process dragging on or not. So the question is, how much self-deception do we have? Of course, you're the expert on self-deception, so we would have to have a second-order self-deception telling us that we had actually scrutinized properly within moral conscience, and then when we actually hadn't. Perhaps that might be an interesting point to make. Then you talk about the incentive, right? And the question of whether what's at stake in the inner tribunal. And I always thought, so the whole role of the fact that there is an inner and an outer tribunal is that only the inner tribunal has access to the incentives. Whereas an outer tribunal looks at mens rea, but is actually just making presumptions on the basis of the externally observable facts. The inner tribunal actually has access to the incentives. And only if we deceive ourselves do we misunderstand these incentives. So I think that it's very, very important. There I would disagree with Timmerman, that moral conscience considers the incentives, but because that's the big difference between the internal and the external forum. And that's why we have the two different ones, and why we are the only ones who can judge ourselves, because we only have access to those. And that's also why Kant writes that we cannot deceive the judge within us, because that is actually the only place where we have the certainty of the incentives. Now coming to the infallibility question. I really try to have it both ways in my account. And of course, it's very, very difficult because I have to say that it's both a feeling, and that's why it cannot be wrong. I don't think that Kant is deceiving the readers, because what he says is that fallibility in conscience would be an absurdity. And I, of course, read that as it would be a contradiction. So he doesn't say that it cannot be wrong. He says that it being wrong would be an absurdity. And I, of course, read that as saying that it's not truth act. But that then commits me to saying that the pangs of conscience, the sanction that is given by moral conscience, which is a feeling, still has to be objective. I cannot say that it's subjective. The question is now, it has to be a feeling from pure practical reason. The question that Martin then raises is, well, that's, of course, respect for the moral law. I don't think so. I think it is a special case of an post hoc respect for the moral law, because it's not an incentive. It's not about future actions. It's not about motivation to be a good person in the future. It's a special application of this feeling on past actions. It's about a very, very specific use of pure practical reason in subsuming actions under the moral law. And I think that in the specificity of it, you get that funny mix between a feeling that is objective. So I think I would probably call it a special retroactive version of respect for the moral law. That would be my solution. I'm just thinking if there's something else I wanted this. Of course, there's a huge literature on this topic. So many people have tried to figure out how Kant can say something like this. And it's really a very interesting debate. But thank you very much, Martin, for this comment. This was wonderful.